Good morning, my magnificent young entrepreneurs. Are you ready to learn some law and make some money? Okay, I hope so. I don't know about you, but I got tired of recording these things in the office and in the kitchen, and so we're doing this one out on my back patio. And we're going to talk about basic employment law in our first module here, and then the second module will be about employment discrimination and sexual harassment and all that stuff. So basic employment law, we need to start with the basic common law rule. It goes all the way back to the beginnings of the industrial era in England, but it is still the basic common law rule today, and that is what is called the at-will doctrine. And what it means is an employee is employed at the will of the employer and also at the will of the employee. So the basic common law rule of the at-will doctrine is an employer can fire you or lay you off, let you go anytime they want to. You're just employed at the will of the employer. The employer can let you go anytime they want to for any reason at all, or even for no reason at all. So that's the common law rule. It's still the basic rule of law today, is the at-will doctrine. You're employed at the will of the employer. He can let you go at any time. By the same token, however, employees work for the employer at the will of the employees. Unless you have a written contract that says otherwise, that says you have to work for this employer for a certain period of time, you can leave anytime you want. We don't have indentured servitude or slavery in this country. So that's the at-will doctrine. Some of you may be shaking your head now and wondering, you're saying, how can that be the general rule of law? Because I know some people who got fired and they sued the employer for what was called wrongful termination. How can anybody be terminated wrongfully if the general rule of law is that the employer can let you go anytime they want for any reason or no reason at all? Well, the fact of the matter is that usually you cannot, under the general rule, the at-will employment law, generally you cannot sue for wrongful termination unless you fall within one of the three exceptions to the rule. So then you want to know, well, what are the exceptions to the at-will doctrine? The first exception is the contract exception. If I hire you and I say, this is a 5-year contract, I'm hiring you to work as a teacher for Sierra College for a 5-year period at $75,000 a year. And then after the first year or two of that 5-year term, I decide I don't like your teaching style and I fire you. Well, you see, I still owe you for the other 3 or 4 years of your contract, because the contract said I was going to keep you on for 5 years. So if we enter into some form of express contract, and then that specifies I'm going to keep you on for a certain period of time, like a number of years, and then I fire you before the end of that contract term, well, you may be able to sue me for wrongful termination. Now remember, however, that would be an express contract that I had breached, and you were suing me basically for breaching the express contract. But contracts can also, the rights in contracts can also be implied. So if I hire you and I have an employee policy manual that says I can't fire you unless I first bring you in and give you a counseling session and tell you what your deficiencies are in your performance, and then I give you 30 days to correct your deficiencies, and if you haven't corrected them by then you can be fired. If my own employee policy manual says that, and I wrote that, or my lawyers wrote it, and then I come in one morning and say, I don't like your face, you're fired. Can I do that? No, I'm breaching an express or implied promise, perhaps, that I'm going to abide by the rules that I made up in my own employee policy manual. So you might be able to sue me for wrongful termination for breach of the implied promise that I would abide by the rules set up in my own policy manual. There is also a implied promise if you have worked for somebody for a long time. Maybe you worked for somebody for 29 years, and at 30 years you could retire and have a nice pension, but at 29 and a half years your employer decides you've become too expensive, and he decides to lay you off and hire a younger person to replace you. you may be able to sue that employer for breach of the implied promise of continued employment based upon long-term employment. Now, how does that come up? How many years do you have to work somewhere before you have that implied promise of continued employment? Well, there's no hard and fast rule about the number of years, but from the case law, it looks like you need to be working somewhere for about 10 years or more before you can rely upon an implied promise of continued employment. There's one aberration case where the time period was as short as 4 years, but generally speaking, it looks like 10 years or more. Now, one last thing about implied promises before we go on to beyond this first exception to the rule, which is the contract theory. In every contract, don't forget, there's always the implied promise of good faith and fair dealing. So if you're fired in a way that is a breach of the implied promise of good faith and fair dealing, you might be able to sue your employer based on that. But there are three exceptions to the employment at will doctrine. The first one is contract. The second one is tort, the tort theory. And the tort theory it's weird because it's not really an exception. You still, if you are employee at will, and the employment at will doctrine applies to you, and you get fired, you may not be able to sue for breach of the employment contract. But if at the time you are fired, your employer kicks you in the tush as you go out the door, you may be able to sue him for the tort that was involved in the firing. There was a battery when he hit you in the tush with his foot, and that's a tort you could sue him for. A more common situation is the boss calls you in front of all the other employees and says you're fired, and the reason you're fired is you're the one that stole the money out of the petty cash box, and you never touched that money. It wasn't you. Well, you're still fired. You can't, because you're an employee at will, you can't sue him for the firing, but you can sue him for the tort of slander. He slandered you in front of all the other employees at the time he fired you. So there's the tort exception. And the third exception is what is called the public policy exception, or the whistleblower exception. And this came out of the cases like Enron, where the employee, a couple years before the Enron financial house of cards collapsed and people lost millions of dollars, there was an employee at Enron who discovered the bookkeeping fraud and reported it to the executives, and what they did was they fired her and swept it under the rug, and they let the fraud go on for a couple of more years before they finally the house of cards collapsed and people lost millions of dollars. So in response to the outrage over the whistleblower firing, it is now against the law for an employer to fire an employee as retaliation for the employee reporting the employer for some kind of illegal activity. So that is the whistleblower, or the public policy exception. We do not want employees to be afraid of getting fired and be afraid to report their employers when their employers are engaged in illegal activity. So we have the three exceptions: the contract exception, which may be either an express or an implied contract; the tort exception, if they commit a tort when they do the firing; and the third one is the public policy or whistleblower exception. And those are the only three circumstances where you can sue your employer for terminating you.